happens after we file? And first off, what are we filing to start our lawsuit?
I mean, I think of litigation as being the most linear thing in the law. It's really almost like a road that goes straight in front of you, and there's lots of benchmarks along the way. So we filed our complaint.
Right. And what goes with our complaint?
You're going to have to do proposed summonses in most courts. And you'll occasionally have a court that will basically just have an ECF, request, issue summons. But 90% of the courts, you're going to prepare summonses and you're going to file those usually as attachments. So you'll have an ECF system. It's hard to picture without seeing the computer, but you're going to file the complaint as the main document, and underneath that, you're going to file a civil cover sheet. You're going to file your exhibits, proposed summonses. Usually that's all I put in the initial, and then you might file a notice of corporate disclosure under Rule 7.1 or something.
Yeah, and if you need that, that'll be in the local rules.
So there are other filings that you will file separately but the same day, and the idea is that you want to file all of your initial documents together in the same day because you want to be able to serve them together.
Right.
So maybe you get your summonses the next day, or maybe the same day, depending on what time of day you file and how busy your local court is.
Right. So just to recap, you're filing complaint, civil cover sheet, exhibits, and proposed summonses. Those are usually the four main things that you need in most cases. So then, now what your summons is it's a form issued by the court clerk's office that allows you to inform the government about your lawsuit in the official way to start their deadline running to respond.
Yeah, I think of it like a subpoena. It's an official court document that says, hey, you've been sued. Here's the caption. Here's the case number. The lawyer for the plaintiffs is X, and you have 30 or 60 days to reply. So it's an official, as you said, official notice, and the delivery of the U.S. Attorney's Office starts the 60-day clock.
Right. And so the clerk issues the form, but you usually have to submit proposed summonses. You have to help them do a little bit of the work, all right? But strict compliance with having proper summonses issued is absolutely essential.
It's jurisdictional.
Yeah. The government will not, if you have defective service, the government will not waive service. They will not... I found them to be pretty strict on enforcing the requirements of service.
It's almost unethical for them to do it because their client doesn't want to respond to lawsuits that they don't have to.
Right.
Without service, you don't have a lawsuit, and the judge will eventually dismiss your lawsuit.
Yeah. If you remember from civil procedure class how the federal rules have provisions for private litigants to waive service, and the benefit is you get additional time to respond, that does not apply to the government. The government has no obligation to waive service of process. So you have to do it strictly. So you get the way you do that is you get your summonses issued, and then you do your mailings.
You download all of the court stamped versions of your lawsuit. Everything you filed was drafts. Everything that you download from the court ECF system, if it has the case number at the top, or sometimes it's the bottom of the page, every page, those are literally the conformed copies of your lawsuit. If you serve an uncase stamped version of your lawsuit, you have not affected service.
Right.
You have to download what you get from the court, you put it together with the summons on top, and then you deliver it to the U.S. Attorney's Office, and then you serve it by certified or registered mail to the Attorney General in Washington, D.C., each of the defendants that we talked about in our service module, but you have to do things very precisely. Mm-hmm. And then after you've done that, you're going to prepare a proof of service. Page 2 of that summons that Mark was talking about, that actually is a blank page where you fill in how you did the service, and then I use the green signature cards for my mailings. I wait till those come back to me, then I will scan them, and I'll make that page 3 of my proof of service.
Sure. We'll say a little bit more about that in our next session on service of process. But after you serve process, what is going to be the next thing that happens? So you said you prepare your proof of service.
I file that with the court,
and then file your proof of service.
My trick is I want to begin negotiations as quickly as possible, and I want to give the chief of the civil division, if you're in a district where one assistant U.S. attorney does all the immigration, then okay, hey Joe, Sally, Ravi, whoever it is, you email them and they will hopefully take it on internally. But if I don't know, I'm going to email the chief of the civil division, and you can find it sometimes on the Department of Justice website. If not, you can call the office and just ask who's the chief of the civil division. And then you just go on to Pacer and you look up their name. You look for, and they're going to have hundreds, if not thousands, of lawsuits. And you just go into one of their dockets, pull off their email address, and I forward them the ECF receipt of the proof of service. Because it says on there, 60-day deadline is August 1st.
Sure.
I forward that showing, hey, I've done proof of service correctly. I know what I'm doing. And I attach a courtesy copy of the summons and the lawsuit. Now that email with the proof of service and the courtesy copy, that's everything that any lawyer needs to actually triage the case. And I say, hey, Chief, I'm Brian, or you know me. I just filed this lawsuit. Could you please let me know when there's a assistant U.S. attorney assigned, or let me know if the DOJ headquarters is taking this lawsuit on. But my email is designed so that way they can forward that directly to their in-house counsel at USCIS or State Department or CBP. I want them to hit forward and make it as easy and quick and simple as possible for them to get my lawsuit into their client's hands and get it evaluated by the client. And as a follow-up, the USCIS has a courtesy copy email address, and DHS Office of General Counsel has a courtesy copy email address. So I email USCIS Chief Counsel and OGC from DHS. I email them the exact same email that went to the U.S. Attorney's Office. I forward it as one email, 2 addresses. Counsel, please find attached courtesy copies.
Right.
Now I've got 3 different emails forwarding the same lawsuit into the client. I want to get as much attention as early in that 60 days as possible, because next thing is going to happen is you have 60 days. The closer you get to the deadline, I feel the less likely you are to settlement. Once they file a motion to dismiss, there's not a lot of impetus for the agency to negotiate anymore. If they win the motion to dismiss, the lawsuit goes away.
So I think what you've been describing is, I would describe that as a pretty proactive approach to managing the litigation. What I tend to do in most of my cases, if I need an urgent response, I would do what you're describing. I don't do that most of the time because it's extra work, and I'm not going to do that unless there's a good reason. Let's say we have a 2-year naturalization delay. Do I care whether I get my settlement this month or next month?
No.
Not really. So in most cases, I'll just do service of process. I'll file my proof of service, and then I'll wait for the U.S. Attorney to contact me, and they'll email you, usually within the 60 days, saying, usually they have some sense of how they want to resolve the case. Either they want to settle it or they need more time. Often we're negotiating to give them an extension. Right. Now, you described a more proactive approach.
I do that more in mandamus cases, because with delay cases, the clients are always time sensitive from the beginning. And if you're talking about like adjustment of status cases, visa bulletins matter. If your client goes through retrogression, if it's October 1st, they may not be able to get a approval, and you might have a dismissed lawsuit for mootness, 12B1 or 12B6.
Yeah.
So I'm more proactive in those. If it's an APA lawsuit over a denial, I wouldn't necessarily. I will reach out, but I'm going to reach out. I'm going to save my credibility for the cases that really need a push.
Sure.
I'm just going to email the chief, say, hey, let me know when this is assigned.
Right.
And I'm not going to, because they're going to produce an administrative record, and that's going to be dependent upon the service center that denied the case. So there are cases like naturalization cases, unless there's an election. If an election's coming up, I feel like the best argument for the judge is disenfranchisement. You want that person to be able to vote in elections.
Yeah.
But otherwise, you're right. Naturalization cases are going to move quickly on their own.
Right. The other way you can get a handle on opposing counsel, figure out who it is you can call the U.S. Attorney's Office. Most of them have a duty attorney, just like a nice chief counsel's office has a duty attorney. They have a duty attorney. You can call and ask to speak to them. Now, they won't have an attorney assigned until you've done service of process.
Yes.
If it's before service of process, they won't really talk to you unless you're seeking an emergency injunction. All right. So you're going to initiate this contact, and in this phase, you're working collaboratively, all right?
This is the waiting game. This is the 60 days where you'd love to see the case resolved, but there's nothing else you can do to push it other than a TRO, which you talked about.
Right. So in this phase, you usually want to work with the U.S. Attorney's Office because so many immigration cases get resolved through settlement, all right? So be nice in this stage.
Judges are going to give an extension the first time they ask for it.
They're going to give them, every judge will give them an extension with little questions asked. So you usually, if they ask you for more time, unless it's an emergency, usually you want to give it.
If you oppose it, the judge is going to probably view you negatively from the beginning of your lawsuit.
Absolutely. And the U.S. Attorney's Office will also view you negatively because you're not collaborating with them to resolve the problem, all right? So you're working with them. Let's say they come back to you. Let's say they ask for more time. Often there's a joint motion to extend their answer deadline.
Or an unopposed motion.
Or an unopposed, yeah. And then within that next window of time, that extended period of time, they might say, hey, here's a request for evidence. So can you respond to this? And we'll continue the deadlines while you respond to this.
I'm negotiating that right now, and my client wants to give 30 days. The AUSA wants 45 days. I always want to give them more time because if you go for the shorter amount of time, then you're going back to the judge 2 or 3 times, and you're actually making it more complicated for yourself, for the other lawyer, for the judge. I want, if the RFE has a 90-day deadline, you need to have a heart-to-heart with your referring lawyer, or if it's you need to talk to your client and say, realistically, can we get this response in 30 days, or do we need the full 90 to give them as much evidence as possible?
Right. So this settlement, if you get an RFE, that's a good thing because that means the agency is figuring out what they need to decide the benefit application.
Or if it's a denial lawsuit and they reopen the case, you get an RFE or a notice of intent to deny, you might still lose, but they're actually going to do hopefully a better job on the case. So you've already achieved something with the lawsuit.
Right. As far as that initial extension, my policy is if they ask for more than 30 days, I need something back from them. I need them to tell me, hey, this is what's going to happen in this time frame.
Or if it's a State Department, you need to know what's the problem here. You want to get something for your client so they feel that there is actually a negotiation and you got some consideration back to law school. But you want to get something in exchange for more than that 30-day.
Right. But I will give them 30 days, kind of no questions asked. I just tell them, hey, the next one is going to require more. If you don't want to do these extensions of time, you can also stay the case.
If the judge lets you.
Yeah, you need a motion to a stay, and usually they will. I have probably 40 cases that are stayed right now.
You have a shadow docket of stayed cases.
I do. So you need a motion, but it's kind of like administrative closure. All the deadlines are taken off. There's no more deadlines, filing deadlines. However, often the judge will order you to file status reports. Usually those are joint. You just update the judge on
every
anything
month,
that's happened.
every 6 months, whatever the judge wants. And it's nice because you're telling the judge that you're working collaboratively with the other side, and you're trying to not have the judge spend time on cases that are not warranted.
Right.
So it's good for you credibility-wise. It's good for your client if you get what you want.
Right. So again, in this phase, you're working with the government, so play nice. So let's talk about when we move into the next phase.
So motion practice.
Yeah. Well, let's just start with the best solution. Let's say it was a delay and your case gets approved. Great. You dismiss your lawsuit voluntarily. Okay. You file a notice of voluntary dismissal.
And do you do that as soon as there's approval online? Do you wait for the green card to come?
I need some official proof. It can be a USCIS notice that they've emailed to me. I don't want to wait an additional 2 weeks in most cases. I used to be kind of a hard ass about I need that green card in hand.
I'm not.
I'm not that way anymore.
Because I've had every AUSA say to me, and in practice follow through, that they will still communicate with USCIS if there's a problem mailing or delivery. So I've had the AUSAs give me tracking numbers, FedEx numbers. They've gone above and beyond. In exchange, I will dismiss as soon as I get that tangible I-797 approval notice.
Right. online state case status that says approved, that's not good enough for me, but some official notice from the agency is fine. It can be an official approval notice, or it can be like sometimes they'll send you the first page of the petition with a stamp approved.
That's great.
That's fine.
You're getting the same thing in a FOIA someday.
Right,
It's official.
Yeah. For asylum, a lot of asylum delay cases get filed. If I get that electronic approval letter from USCIS, I'm good to dismiss.
If I get a notice that there's going to be an interview, if there's an MVC receipt, I mean, if my client gets what they want, I try to convince the client to dismiss without prejudice at that point, because the AUSA is not going to betray and not follow through.
Yeah.
And at the same time, I want to, if they have 500 cases on their docket, I want to make that AUSA's job easier, because over 20 or 30 years of doing that, they will help me when they might not help another lawyer.
Right.
You want to establish credibility, and you want to be the lawyer they want to work with.
Yeah, and I think we should, let's say a little bit about, I mean, we've been alluding to it, but let's talk about how you work with assistant U.S. attorneys and DOJ attorneys generally. Honestly, of all the people that I've interacted with in government, from the lowest level up to the highest level, cabinet secretaries, whatever, honestly, the people who I have consistently the best interactions with is assistant U.S. attorneys.
They are career civil servants. Oftentimes, they will spend 20, 25 years doing the same job. They are, as we said, they're super general practitioners. They do every part of civil litigation, slip and fall, medical malpractice, employment defense, everything you can think of, they do at the federal level. And they might become a judge someday, or a magistrate judge. But they're going to be there before and after we are, and they know the judges well, so you really do need to try to work well with them. Some people have different styles. Some people are more antagonistic. I've never found that it really worked.
Right. You know, my wife has practiced commercial civil litigation, where it seems like the attorneys are very nasty to each other. I've never had that. I love working with U.S. attorneys' offices. Most of them want to do justice. They want to do the right thing. They want to see their agencies following the law. They want to dispose of their cases without unnecessary work. So all of this inclines them to work with you to resolve whatever problem it is that caused you to take such an extreme measure of filing a lawsuit.
Well, one thing I found with my referring lawyers or my co-counsel that don't do exclusively litigation is that they end up personalizing the lawsuits, because maybe it's their client. They have like 5 or 6 years invested in this client, and I understand, but litigation needs to be cold-blooded. It needs to be calculated. It needs to be fair and just. And they often will confuse the assistant U.S. attorney, their old attorney, with the client. They will say, well, why is this DOJ lawyer not agreeing to this? They're a lawyer. The client makes decisions. That big faceless, monstrosity is USCIS. They make the institutional decisions. Don't blame the person who's working and getting a salary and doing their 50, 60 hours a week.
And so you're right. You do need to understand the difference between the attorney and the client on the other side, and the other side also sometimes needs to understand the difference between you and your client. Sometimes if you need to preserve good relations with the U.S. Attorney's Office, sometimes you can be upfront and say, hey, this is my client's position. I don't love it, but that's our position. So, that way you build kind of a mutual professional respect for each other.
And not being afraid to litigate, not being afraid to go to motion practice. They're doing hundreds of motions a year. We, as the private bar, need to have the capacity and the skill set to do well-researched briefs, to argue well in front of judges. And you're going to lose, and you're going to win, and you're not going to know which one you're going to win or lose. And that's litigation. It's not this 90% approval that people are used to with USCIS.
Right.
So you can't guarantee results.
And so when you're talking with the U.S. attorney, you can talk more constructively and effectively if you are aware that this is not about them personally, that they have a client, they have their own relationship with their client. They might not be able to get their client to do everything that the court wants them to do sometimes, right? We've seen a lot of that lately, and it's not the DOJ's fault. So again, play nice with them. It's going to pay off in the long run. And again, most immigration cases resolve peacefully through settlement.
Most mandamus cases are going to resolve, and you're going to very rarely ever see an answer filed.
Right.
You may see that more frequently when you're challenging an APA denial.
Yeah.
They have a pro form answer that denies everything and says this is an agency, these are all factual, legal conclusions, blah, blah, blah. But then you'll either get that answer or you'll get a motion to dismiss under Rule 12.
Right.
And at that point, the nice thing with the government is that they often use the exact same templates over and over. Mm-hmm. So your first time you're doing an opposition to a motion to dismiss on a delay case, it's hard. You have to do some research. Mm. When you're doing your 20th, it's going to be updating the circuit law for a different court, but the same basic track functions.
Right.
And we'll talk about that more in a different module, but motion practice should become routine the more that you do it.
Yeah. So let's get back to the life cycle of litigation. So you're doing this initial negotiation. Hopefully that's the end of the case, and that's great. Often you're doing extensions of time or a motion to stay. What happens if you get past that? Your case needs to continue, and it kind of heats up.
Well, as I said, you're going to get an answer or a motion.
Yeah.
And if there's a clear enough delay, if it's been 7 years, I don't know that the DOJ would spend time on a motion there. Right. They're going to file an answer. If it's a denial case, there is jurisdiction, unless it's a discretionary benefit. If it's something like an I-601 denial, you're asking for a waiver of something, you'll get a motion to dismiss there under 12b-1. And maybe 12b-6 too.
Yeah.
But you're going to see an answer or a motion, and then you're going to have to deal with that. And then a judge in D.C., they might take a year to issue a decision on a motion to dismiss.
Right.
So you might be in that stay, even though it's not an official stay, you might just be in this purgatory for 12 months. And in fact, a lot of cases resolve during that time, and you need to withdraw your lawsuit so you don't get a negative decision from that.
Right. That's right. So,
or your referring lawyer needs to be a good enough general person that they tell you that the visa was issued, and you don't get a motion to dismiss granted in writing in Westlaw and Lexis saying you lost when in reality you won because the case mooted out.
Right. So you're going to get one of 3 filings generally, maybe 4. An answer, a motion to dismiss, a motion to summary judgment, or sometimes a motion to change venue, right? I think that's kind of the 4 actions that you're most likely to see after you get past that initial negotiation phase.
Yeah, the first 2 are common. The second 2 are not, because some places the judges don't want motions for summary judgment filed early.
Right.
And at least in Nebraska, where I'm filing, they only let you file 1 for the entire case. So if you file a motion, some people file a motion to dismiss or in the alternative motion for summary judgment.
Right.
That's discouraged by the judges because it's more work.
Right.
And in D.C., there's a local rule that prevents you from filing a motion for summary judgment.
Right.
And so there's going to be, you're most likely going to see a motion to dismiss, less likely to see an answer, less likely to see a motion to change venue, and then the least likely to be summary judgment.
Right. So let's map out, let's say you get an answer. You're most likely to get that when you're doing an APA case that's challenging the denial of a benefit, probably a petition. So you get that answer, they'll deny most things. They might agree to a couple crumbs, right?
It's useless in essence.
And then I go back to my complaint and I highlight the couple of crumbs of facts that they conceded, which is helpful. So then after that, you move into the next phase of the litigation. Usually there will be status conferences. There will be a plan made for them to produce the administrative record, and then to usually do summary judgment briefing.
And you have to have a conference with the opposing side. You have to put together a joint proposed scheduling order, and you have to lay out briefing deadlines. You have to list any witnesses, evidence. You have mandatory disclosures under Rule 16 and Rule 26. So you're going to have to do all this proactive work that the court expects you to know how to do and to do it. And we said earlier in one of our other modules, the judge may have a prescribed form for these filings. If not, the AUSA probably already has done it 100 times. And if you're collegial with them, they might even give you a working copy you can work from. So you're going to have to do filings to plan out the case, and then you're going to move forward to that really the motion for summary judgment is where most of these cases, whether it's delay or denial, it ends up in a on the record or on the papers decision.
Right. So that's one pathway. You get an answer and then move on to summary judgment. Let's say the initial filing from the government is a motion to dismiss. So we talked about the two types: motion to dismiss for lack of jurisdiction, that's FRCP 12b1, and then motion to dismiss for failure to state a claim, that's 12b6. So what happens if you get one of those motions?
You look at your local rules, and it's going to say you have 14 days to reply, you have 21 days to reply. It's from the date of the ECF filing, which is also instantaneously the email receipt you receive. So you're going to basically, I use timeanddate.com. It's a great website. It'll calculate for you, just say, okay, 14 days from this filing date. Go ahead and calendar that deadline, because a lot of this is case management issues. And then you're going to basically look at their brief. You're going to go into the Westlaw or Lexis or Fastcase. You're going to research every single case they cite. Hopefully they're not using AI, there's no hallucinations, but you will often find that the DOJ is saying that the case says one thing, but does it really say that? Or can you differentiate that case? You want to shepherdize or key cite it, because there are cases that might say the opposite. And they'll often say, well, okay, this case in Massachusetts says this, but you're in Nevada. You want to look for a Ninth Circuit case. And I always start with researching the judge assigned to the case, look at his or her cases first, and then go to the district, then go to the circuit, then go nationwide.
Right. And so all this is in service of preparing an opposition to their motion to dismiss. So, and then after you file your opposition, they probably get to file a reply. And then if there's going to be a hearing, oral argument, then that will get scheduled in accordance with the court's normal procedures. Or there might not be a hearing. So then if the motion to dismiss is fully briefed, then it goes to the judge, and they take however long the judge wants to decide it. 6 months is perfectly normal. A year is not uncommon, though I personally haven't had to wait that long in most cases. And also, by the way, settlement talks can continue even after a motion to dismiss is fully briefed. We'll see that often with State Department delay cases. They'll act like they're fighting the whole case, but in truth, it seems like there's some wheels working behind the scenes to continue to resolve the visa application.
And that's on the government side. I just had a client tell me she's actually waiting for her F1 visa to return for STEM, but she's actually in Haifa, Israel, and there's a war going on right now. There's rockets going from Iran to Israel and back. So she said, when you go to oral argument in Boston remotely, please tell the judge, I'm in Haifa, I'm at risk from these rocket attacks. That changes the track analysis.
Wow,
so you need to work on, it's horrible, but as a lawyer, it's something that may change the judge's decision making. So the government may be able to move the case through processing. We need to check in with our clients to make sure that what we said to the court is still accurate. Right. And also, if we see case decisions, you might want to do a notice of supplemental authority.
Of course. So a lot of your motions you can supplement. It might not be technically allowed by the local rules, but if there's something real that the court needs to know about, you do want to file that supplement. Usually you're not going to get dinged or penalized for that. So you brief your motion to dismiss. If the judge grants the motion to dismiss, then your case is over. You need to look at appealing.
Probably it's going to be without prejudice.
Yeah, or refiling.
And you might have leave to file an amended complaint in certain situations.
Right.
But then if you do have a dismissal, you want to talk to the client and manage their expectations. How long is a changed circumstance to refile the lawsuit? Is it going to be a year? Is there going to be a humanitarian reason that changes the track factors? Because you might end up with the same judge again.
Right.
And that judge is not going to be happy if you're back a month later.
Right. So if the judge denies the government's motion to dismiss, usually the government will settle with you after that. If they don't, then you continue to summary judgment briefing. It's pretty uncommon to have a decision on a motion to dismiss that's contested, and then also a decision on summary judgment that's contested. That's kind of rare. It seems like after the government gets their motion to dismiss denied, usually they see the light and they see that the judge cares about this case.
That's a sign that they may lose at summary judgment.
Right.
Because if there's a clear timeline that the judge says, well, in our circuit, anything under 3 years or 4 years, if you get past motion to dismiss, you need to negotiate, and the government needs to negotiate.
Right. However, keep in mind, that the set of facts that the judge assumed for the motion to dismiss, those might not be the facts that the judge ends up finding if you continue.
Yeah, so the light most favorable to the non-moving party.
So on the motion to dismiss, the court has to assume the facts in your favor to the non-moving party. However, when you get to motion for summary judgment, you have to prove your facts. So there might be some daylight there.
And judges want cases to settle. So at that point, if the government's not willing to negotiate or they're not being reasonable, I ask the judge for mediation. I ask the judge, I've had this in California, it worked fantastically, just because mediation at the federal court level is usually free. So they'll get you a magistrate judge or another judge, they'll do a half-hour, 1-hour mediation call, and then the DOJ will be like, we have to settle this case, and then the client for DOJ will use that as an excuse to go ahead and say, well, this is not a pattern for us. We're going to settle this case because Judge so-and-so wants it to be settled. So mediation at that point can be a very effective tool if you're not getting, because a lot of times the DOJ will say, well, my client, how about we do a visa interview in 65 days? Or what if we get USCIS to issue a decision in the next 4 months? They'll try to put out something that's a give and take.
Yep, right. And if they've come up with something reasonable, usually you have to take it because you're not going to do any better in court.
Well, the only thing is the leverage you have is that if you win at summary judgment, you might get EJIA fees.
Yeah.
And that comes out of the agency's budget.
Yes. However, that's pretty infrequent, right?
I think I've won them twice out of 3,000 cases.
I've also won them twice. Yep.
Settlement, you don't get EJIA fees out of settlement.
Right.
You get them out of a written decision.
Except in FOIA.
In FOIA.
You might. All right. So let's see. We talked about motion to dismiss. Let's say their first pleading is a motion for summary judgment. Now, let's say that this happens even before they file an answer. Now, I don't like it when the government does this because it's like they're trying to skip the whole litigation life cycle. So there is a rule, if you don't like this, and they're fighting your case, usually it's in your benefit to try and push them to develop the facts about the case, the evidence. Get the administrative record. If you need additional evidence, press for an opportunity to get that.
Rule 56D has a provision for this.
Right. Rule 56D. What it is a motion to defer ruling on summary judgment based on the fact that there's facts that you need, some evidence that you need that is unavailable.
Yeah, they'll attach an affidavit from an agency officer. They'll attach that to their motion and say, Judge, this is all you need.
Right.
You've got some evidence on the plaintiff's side with their complaint. Here's everything you need from the agency. Go ahead and make a decision on this. And you have to know the rule and know that there's relief available and show the judge, no, there's more here.
Right.
We need to know what's going on at the embassy in Poland.
Right. If their first filing is a motion for summary judgment and all you do is oppose that, I would describe that as a little bit soft litigation tactics. Usually you need to do something more aggressive. You need to file a cross motion for summary judgment at least, or you need to do a 56D motion.
Or both.
Right, or both.
Without a cross motion, you can't win the case. You can only not lose the case.
Right.
So you need to think about, what's my end game here? And I have to give the judge the procedural vehicle to give me what I want. And also with those government affidavits, they often contradict themselves. Yeah. So if you know the officer's name or the visa office, attorney advisor, go out and research them and see if there's other pleading or other affidavits that they filed. Pull them all together and see if they're making discrepant statements.
Right.
That's really great to put in your opposition.
And share them with other attorneys.
Use the AILA, use your listservs, ask other people, and crowdsource and get, because that's what the government's doing. They're using all of their abilities. You don't stand alone. You need to use, and you need to research them to see how many other times they've been involved in cases.
Right. And the government in their affidavits, they're good at papering over the real issues.
They like to reframe your complaint. And they do that in motion to dismiss often.
Yeah. And so one other big benefit of sharing any materials you get from the government is that another lawyer is going to see something in it that you didn't see. Yeah. Right? It's reading in between those lines. What are they not acknowledging?
It's not AI, it's groupthink.
Yes, right.
Different skill sets, different people have different abilities. Other people are not tired when you're tired.
Yeah.
It's really, and then we're all on the same side. At least the immigration bar, we all fight against the government. We're like the criminal defense bar. We only have one attack direction, it's toward the government. So if you help people out, they'll help you back.
Right, absolutely. All right.
Is there anything after summary judgment?
Well,
It is
it's either granted or denied.
Or granted in part and denied in part.
Yeah.
And judges will often remand cases if it's a denial, or they will issue an order to the defendant saying you have to do such and such
Right.
within such and such amount of time.
Right. So that's the litigation life cycle.